Hi, my name is Seneca Rose, and today I will be discussing about the revised Penal Code Act 3815. But for this video, I will only limit my discussion from Article 2 to Article 11 of the revised Penal Code. So before we tackle each of the articles, let us first define what is a criminal law. So basically, a criminal law is a branch or division of a public substantive law which defines crime, threats of their nature, and provides for their punishment. So what about crime? What is crime? So crime is an act or omission in violation of a public law forbidding or commanding it. So much for that. Let us now discuss Article 2 of the revised Penal Code. So now we are going to talk about the Article 2 of the revised Penal Code. So by the way, I am using the book of Judge Abudiente in the reference for this video. So what does Article 2 of the revised Penal Code talks about? So basically, Article 2 talks about the application of its provision. So it is stated here in Article 2 that this code shall be enforced not only within the Philippine archipelago, which includes its atmosphere, interior waters, maritime zone, but also outside the Philippine jurisdiction, which I will be going to explain in each of the paragraph. So now we are going to talk about the first paragraph of the Article 2 of the revised Penal Code. So this first paragraph, it talks about the crime committed on board of a Philippine ship or airship. So what does this ship refers to? So this ship refers to a Philippine commercial ship. It is a registration of a vessel which determines its nationality, not the nationality of its owner. So whether the owner of the ship may be an American, Chinese, or Japanese, as long as the ship is registered to the Philippines, then this ship is a Philippine ship. So when the crime is committed on board on the Philippine ship within the neutral within its neutral territory or high seas, then 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 the said crime is triable in the Philippines. And now let's talk about the second and third paragraph of Article 2 of the revised Penal Code. So this second and third paragraph talks about forged coins or currency notes of the Philippine Islands. So even though this crime is committed outside the territory of the Philippines, still the trial would be in the Philippines for the reason of public policy. And now let's talk about the paragraph 4 of the Article 2 of the revised Penal Code. So paragraph 4 talks about the public officers or employees who committed an offense in the performance of their duty. So penal laws have what we call extraterritorial application for those crimes committed abroad by public officers or employee. Such crime which relates to their public functions, such as direct bribery or falsification of public documents. If ever public officers committed crime which does not relate on their public functions such as kidnapping, rape, uh, and etc., this crime will be uh, will have a trial on the country where the crime is committed. And now let us talk about the last paragraph for Article 2 of the Revised Penal Code. So paragraph number 5. So this talks about the crimes committed against national securities and the laws of the nation. So these crimes are defined and penalized under Article 114 to Article 123 of the Revised Penal Code. So these crimes such as treason, conspiracy and proposal to commit treason. So crimes like this are punishable and triable in the Philippines. So that ends for Article 2 of the Revised Penal Code. And now let's talk about Article 3 of the Revised Penal Code. So what is this Article 3 talks about? So basically, Article 3 talks about felony. It defines what is a felony. So what is a felony? So basically, felony is an act or omissions that are punishable by law. But how can we say that a person is committing a felony or that a person is doing a felonious act? So there are three requisites that we can identify if that act is a felonious act of or if a person is doing a felony. So first one, so there must be an act or omission done. Second, the act or omission must be punishable by law. Third one is the act or omission committed by means of deceit or by means of fault. And that's how we're going to say that this certain act is felony. So a person might be committed an act. So this act must be committed by means of deceit. But if there is no law punishing this act, then this act cannot be considered as felony. So for example, I have these examples. For example, Juan. Juan was so desperate in ending his life. So that's why he has a rope and he hung himself. However, his brother arrived timely, so Juan got saved. So the question is Juan liable committing a felony? No, because there is no such law which punishes a person that commits suicide. So how can we identify if a felonious act is committed by means of deceit or by means of culpa? So a felonious act is committed by means of deceit if these three things are present. So the first one is freedom. Freedom of a person to commit a crime or the free will of a person to do a felonious act. Freedom is important because an act by me which is against my will is not my act. The next one is intelligence. So a person must be a criminal, has a criminal mind in doing a crime. So we could consider this crime committed by means of deceit. Then the next one is intent. If a person has a criminal intent in doing a felonious act, then we could consider this act is committed by means of deceit. So a felonious act is committed by means of deceit if these three things are present: freedom, intelligence, and intent. And when a felonious act is committed by means of culpa, three things are also must be given consideration. So it is a freedom, intelligence, and negligence. Negligence of the act. And now let's talk about the difference between mala inse and mala prohibita. So mala inse is an act or omissions that are wrongful in nature, while mala prohibita are acts or omission which have made punishable by law in order to give a more secure to a more orderly regulations of the affairs of the society. So in mala prohibita, even if you have a good intent or you have a good faith in doing such act, if you done things under the law, then you are liable. While in mala inse, intent is necessary and that you can use good faith as a defense. And now we are going to talk about Article 4 of the revised Penal Code. So Article 4 basically talks about criminal liability. So a criminal liability shall be incurred in two situations. So first, by any person committing a felony, although the wrongful act done be different from what that which he intended. And the second one is by any person performing an act which would be an offense against person or property, were it not for the inherent impossibility of its accomplishment or on account of the employment of inadequate or inflectual means. So what does paragraph 1 of the Article 4 talks about? So under this paragraph, the initial act of the perpetrator must be for the purpose of committing a felony in order for him to be liable for all the direct, logical, and natural consequences of his action. So I will give you an illustration for this paragraph. So let's say that Juan, without any intention to kill, punch or box Pedro on the face, which causes Pedro to fall down and struck his head on the pavement, which causes him to have an intracranial hemorrhage, which causes Pedro's death. So the question is Juan liable for the death of Pedro? Yes, Juan is liable for the death of Pedro because at the time Juan punches Pedro, he is already committing a felonious act, and that the consequence of that which is Pedro's death. So Juan must be liable for the consequence of his felonious act. So now let's talk about proximate cause and mistake of fact. So under paragraph 1 of Article 4, that is the basis of the concept of what we call proximate cause. So from my example, wherein Pedro's death was caused by Juan's felonious act, so that is an example of a proximate cause. So basically, a proximate cause is a responsible cause. Now, what is mistake of fact? So while ignorance of the law excuses no one from compliance therewith, ignorance of the fact excuses. So how can we say that the act is based on ignorance of the fact? So there are three requisites. So first one, the act must be lawful. Second, the intent must be lawful, and the mistake done was not by means of negligence. Now let us use the case of US versus Achong as an example of the mistake of fact. So this case talks about Achong, who accidentally stabbed and killed his roommate in belief that his roommate is a thief due to the rampant robbery which happens in the place which they were residing. So the court ruled in this case that Achong is not criminally liable for killing his roommate since Achong has no criminal intent to do those acts. He don't know that it was his roommate. So this act or this case was a mistake of fact and that Achong is not criminally liable for his act. And now let's talk about paragraph 2 of Article 4 of the Revised Penal Code. So basically this paragraph talks about impossible crime, which is punishable by law. So these impossible crimes are crimes only that happens against person or property. So what is this impossible crime? So impossible crime is an act of an offender which cannot cause or produce an offense against person or property. Thus, if you commit this crime, this is still punishable by law because of the criminal intent of the offender. So, one example of an impossible crime is that when you try to kill someone and you want to poison someone's drink but you accidentally put a sugar instead of a poisonous things on the food of the offender. So when the offender drank it, so he did not die. But you committed a felonious act with that, with a criminal intent of killing that offender. And what you did is an impossible crime. And now let's talk about Article 5 of the Revised Penal Code. So basically, Article 5 stated that duty of court in connection with acts which should be represented but which are not covered by the law, and in case of excessive penalty, whenever a court has knowledge of any act which it may deem proper to repress and which is not punishable by law, it shall render the proper decision and shall report to the Chief Executive through the Department of Justice the reasons which induce the court to believe that said act should be made the subject of penal legislation. In the same way, the court shall submit to Chief Executive through the Department of Justice such statement as may be deemed proper without suspending the execution of the sentence, when a strict enforcement of the provision of this code would result in the imposition of a clearly excessive penalty, taking into consideration the degree of malice and the injury caused by the offense. So basically, Article 5 just talks about the duty of the court. So first one, in the connection with acts, should be repressed but which are not covered by the law. So example for this is, let's have a situation wherein Juan discovered a that a durian seed can be dried and then powdered and then he sell it, which effect is the same as an illegal drugs. And then Juan sold it to many people. So the question is Juan liable for this act? So no. Why? Because there is no law that punishes someone or a person selling a powder or a durian powder. So therefore, Juan is not liable for selling the durian powder. So basically, if there is no law for a certain act, so the court must have a proper decision, and that is to dismiss the case. And also, Article 5 talks about excessive penalties that an offender might get when he committed a felonious act, and that is also a duty of the court. And now, we are going to discuss Article 6 of the Revised Penal Code. So basically, Article 6 talks about the consummated, attempted, and frustrated felonies. So in this article, we will going to understand the difference between consummated felonies, frustrated felonies, and attempted felonies. And now let's talk about consummated felony. So a felony is said to be consummated when all of the elements necessary for the execution and accomplishment are present. So let's take the example of the case of People versus Mario Castro, in which Mario Castro is ruled as having liable for a consummated rape. So in cases of rape, Supreme Court ruled that complete penetration of the female organ is not really necessary because even the slightest penetration of the female organ is already considered as a consummated rape. And this happens or this rule in the case of People versus Mario Castro. So now let's talk about frustrated felony. So what is frustrated felony? So a felony is considered to be frustrated when the offender performs all the acts of execution which would produce the felony as a consequence, but which, nevertheless, do not produce it by reason of causes independent to the will of the perpetrator. And now, let's have an example of arson as a frustrated felony. So, if there is no part of the building that was burned, but it was just a blaze, so this crime is a frustrated arson. And now let us discuss attempted felony. So, what is attempted felony? So, a felony is said to be an attempted felony when the offender commences the commission of the felony directly by overt acts and does not perform all the acts of execution which should produce the felony by reason of some cause or accident other than his own spontaneous desistance. So what do you mean by overt act? So overt act is a physical act done to carry out intention or criminal resolution. So in the case of People versus Kampuhan, the Supreme Court ruled this case as attempted rape because the victim says that the accused penis just touched her organ but did not penetrate it. So the Supreme Court ruled the decision as attempted rape. So there are stages of commission of felony under Article 6 which do not apply the following. First one are those crimes which are punishable under special penal laws, unless the same specifically so provide. Thus, there is no attempted or frustrated illegal possessions of firearms or prohibited drugs. Number 2, when crimes of omission unless the acts performed constitute another offense. Thus, their damage to property through reckless imprudence has no attempted or frustrated stage. And the last one is formal crimes which are committed in an instant like physical injuries. And now, let's talk about Article 7 of the Revised Penal Code. So Article 7 talks about light felonies. When light felonies are punishable. So light felonies are only punishable when they have been consummated, with the exemption of those committed against person or property. Example of light felonies against person is slight physical injury and maltreatment. And example of light felonies against properties are theft, alteration of boundary marks, and malicious mischief. Now let's go to Article 8 of the Revised Penal Code. So Article 8 talks about conspiracy and proposal to commit felony. So conspiracy and proposal to commit felony are punishable only in the cases in which the law specially provides a penalty therefor. So a conspiracy exists when two or more persons comes to an agreement concerning the commission of a felony and decide to commit it. And there is a proposal when a person who has decided to commit a felony proposes its execution to some other persons or person. Mere conspiracy and mere proposal to commit a felony is not at all times punishable by law. So now let's take an illustration. So for example, XYZ are planning to commit a robbery to A which is a balikbayan, and then B which is a helper of X overhear their conversation or overhear their plan of robbery. And so B tell the police about their plan. And so on their way of committing a robbery of XYZ, the police stopped them on checkpoints and found out that they have firearms. And so the police filed a case of conspiracy to commit robbery. And so the question here is X, Y, and Z liable for conspiracy of robbery? No, because a mere conspiracy to commit a robbery is not a crime, and that's why their act is not punishable. In conspiracy, the act of one is the act of all, so it doesn't matter on what degree or what kind of participation you are in, as long as the conspiracy is clearly established. And now, let's talk about Article 9 of the Revised Penal Code. So Article 9 basically talks about the classification of felony according to gravity. So grave felony, less grave felony, and light felony. So what is grave felony? So basically grave felonies are those to which the law attaches the capital punishment or penalties, which in any of their periods are afflictive. While less grave felonies are those which the law punishes with penalties which in their maximum period are correctional. While light felonies, on the other hand, are those infractions of law for the commission of which the penalty of arresto menor or a fine not exceeding 200 pesos or both is provided. So what are these afflictive penalties which are mentioned in grave felonies? So afflictive penalties are under Article 25, which are reclusion perpetual, which is 20 years and 1 day to 40 years. Reclusion temporal, which is 12 years and 1 day to 20 years. Perpetual or temporary absolute disqualification, perpetual or temporary special disqualification, and prison mayor, which is 6 years and 1 day to 12 years. So what are these correctional penalties which are mentioned in less grave felonies? So correctional penalties includes prison correctional, which is 6 months and 1 day to 6 years, arresto mayor, which is 1 month and 1 day to 6 months, suspension, and distero. Light felonies, on the other hand, as what is mentioned on Article 7, are only punishable when consummated, with the exception of those committed against person or property. Now, let's talk about Article 10 of the Revised Penal Code. So, Article 10 talks about the offenses not subject to the provision of this code. So, this means that the offenses which are or in the future may be punishable under special laws are not subject to the provisions of this code. So, this code shall be supplementary to such laws unless the latter should especially provide the contrary. This article emphasizes that the provisions under the revised penal code are not applicable to those punished under the special law unless the latter provides that the provision of the revised penal code are likewise applicable. So this will be the last article that I will be discussing for this video, and this is Article 11. So basically, Article 11 talks about justifying circumstances. It talks about circumstances that are justifiable. So when you say circumstances that are justifiable, it means that circumstances that do not incur any criminal liability. And now we will going to discuss the first paragraph of Article 11. So this paragraph talks about defense. So anyone who acts in defense of his person or rights provided that the following circumstances occur. So first circumstances is unlawful aggression. Second is reasonable necessity of the means employed to prevent or repel it. Third one is the lack of sufficient provocation on the part of the person defending himself. So the first justifying circumstances is generally known as self-defense. And in order to prove that you are doing such self-defense, you must prove three circumstances. So the first one is unlawful aggression. So unlawful aggression means an attack or an assault. So there should be an unlawful aggression to prove that you are doing a self-defense. So for example, the scenario of A, B, C, and D, which are playing gamble or the play known as tong its. And then suddenly, A noticed that B and C were secretly exchanging cards, so meaning they are cheating on that game called tong its. So due to anger, A grabbed his knife and struck B. But then B parried his knife and then fight back to A. Then A realizes that he can't stand with B because B is a bigger man than him and he's stronger than him. So A basically ran away. But then B chased A and then stuck him with his knife. So the question is B doing a self-defense? So basically the answer is no, because even though the initial unlawful aggressor was A ran away. So then it becomes B becomes the unlawful aggressor now. So B is not doing a self-defense. And the next one is the reasonable necessity of the means to employed to prevent or repel it. So for example, there is a strong and healthy man who uses a bat in order to defend himself against a woman. So his act is not an act of self-defense. Why? Because a man is using too much force or exert too much effort or inappropriate force to defend himself against the woman. So there is no self-defense in that situation, because in self-defense it needs an necessity or a reasonable means to employ that act. thing is the lack of sufficient provocation on the part of the person defending himself. It is to be noted that the word provocation is preceded by the word sufficient. What is sufficient also depends on the situation and the circumstances of the parties. And now let's go to the second paragraph of Article 11, which talks about anyone who acts in defense of the person or rights of his spouse, ascendants, descendants, legitimate, natural, or adopted brother or sister, or relatives by affinity within the same degree, or those of consanguinity within the fourth civil degree. So basically, paragraph 2 of Article 11 talks about defense of relatives. So the term relative here means with the same degree. So this paragraph states that when you are defending your relative or you are doing an act which defends to your relative, so it means that you are not criminally liable of doing such act as long as it is an act of defense. And now, let us discuss the paragraph 3 of Article 11, which stated that anyone who acts in defense of the persons or rights of a stranger, provided that the first and second requisite mentioned on the first circumstance of this article are present, and that the person defending be not induced by revenge, resentment, or other evil motive. So basically, paragraph 3 is somehow the same of paragraph 2. It's like a defense, but in this case, it is a defense to strangers. So the term strangers here refers to those people which are not included among the class of your relatives. So when you defended someone which is not your relative, as long as you are doing a self-defense act, then it means that you are not criminally liable of doing such act. Now, let's talk about paragraph 4 of Article 11. Paragraph 4 states that any person who, in order to avoid an evil or injury, an act which causes damage to another, provided the following requisites occur. So the first one, the evil sought to be avoided actually exists. Second, the injury feared be greater than that done to avoid it. And the third one is there is no other practical or less harmful means to prevent it. Basically, paragraph 4 of the Article 11 talks about a defense done in order to prevent an injury or an evil that might be happen, or a defense is done in order to prevent greater injury that may happen, and that there is no other practical ways to prevent the injury. Now let's talk about paragraph 5 of Article 11. Paragraph 5 talks about any person who acts in fulfillment of a duty or in a lawful exercise of a right or office. Fulfillment of a duty will only be justifiable in circumstances such as the person committed an act which caused damage or injury to another. The second one is the injury was the consequence of the lawful performance of a duty or in a lawful exercise of his right or office. And now let's talk about the paragraph 6 of Article 11, which talks about anyone who acts in obedience of an order issued by a superior for some lawful purpose. So the obedience of an order of a superior. For this to be validly appreciated, the following requisite must occur. So the first one, the person was ordered to perform an act which caused damage to another. Second one, that the order was issued by a superior. Third one, the order is for lawful purpose. According to this provision, blind obedience to any order could not justify one's act. For the act of a subordinate to be justified under this principle, he must perform it in accordance with a lawful order. If the order is not lawful, he is not duty bound to obey it. So, for example, if a policeman therefore were ordered to summarily kill robbers who were already captured and rendered powerless, and they blindly obey the said order, they could not escape the criminal liability on the ground that they obey the order for their superior. Since I'm already done discussing Article 2 to Article 11 of the Revised Penal Code, now let us continue our discussion to Article 12 up to Article 20 of the Revised Penal Code. And now, our first discussion will be Article 12. So basically, Article 12 talks about the circumstances which exempt a criminal liability. So in this article, we have 7 paragraphs and we will discuss each paragraph in detail. Now let's talk about the first paragraph of Article 12, which refers to an imbecile or insane person, unless the latter has acted during lucid interval. So when an imbecile or an insane person has committed an act which the law defines as felony or delito, the court shall order his confinement in one of the hospitals or asylums established for persons thus afflicted, which he shall not be permitted to leave without first obtaining the permission of the same court. And now let us talk about the difference between imbecility and insanity. So imbecility is a permanent mental affliction, and an imbecile therefore is always exempt from criminal liability, while insanity, on the other hand, in the eyes of the law exists when there is a complete deprivation of intelligence in committing the act. That is, the accused is deprived of reason. He acts without the least discernment because there is a complete absence of the power to discern. And now let's talk about paragraph 2 of Article 12. So basically, paragraph 2 exempts a person under 9 years of age. Thus, even if a minor has a discernment and shows high intelligence, the law declares him statutorily innocent for as long as he is 15 years of age or under. This exemption is based on the actual age and not on the mental age of the accused. And now let us proceed to paragraph 3 of the Article 12. So paragraph 3 talks about a person over 9 years of age and under 15 unless he acted with discernment, in which case such minor shall be proceeded against in accordance with Article 80 of this code. So when a minor is adjudged to be criminally irresponsible, the court, in conformity with the provision of this and the preceding paragraph, shall commit him to the care and custody of his family, who shall be charged with the surveillance and education. Otherwise, he shall be committed to the care of some institution or person mentioned in the said Article 80. Now let us define what is discernment. So discernment refers to the mental capacity to fully appreciate the consequences of his act. It means it is the ability to understand and appreciate the distinction between right and wrong. So under RA 9344, a child refers to a person under the age of 18 years. Under Section 6 thereof, A child of 15 years of age or under at the time of the commission of the offense shall be exempt from criminal liability. Under the same provision, a child above 15 but below 18 years of age shall likewise be exempt from criminal liability and be subjected to an intervention program unless he or she has acted with discernment, in which case such child shall be subjected to the appropriate proceedings. Now let us proceed to paragraph 4 of Article 12 of the Revised Penal Code, which talks about any person who, while performing a lawful act with due care, causes an injury by mere accident without fault or intention of causing it. So accident is a happening or an event that takes place without one's foresight or expectation. So for example, in the case of People versus Bindoy, the accused and Pacas were struggling for the possession of Bindoy's bolo. Bindoy succeeded in wrenching the bolo from the grasp of Pacas, but in the process, the pointed edge of the bolo hit the chest of a bystander who was behind Bendoy. So the court acquitted Bendoy. There was no criminal intent to fault to kill the bystander. Now let us proceed to paragraph 5 of Article 12, which talks about any person who acts under the compulsion of an irresistible force. So let us define what is a irresistible force. So it refers to the force which produces such an effect upon an individual that, in spite all resistance, it reduces him to a mere instrument and as such incapable of committing a crime. So a person who acts under the compulsion of an irresistible force, like one who acts under the impulse of an uncontrollable fear of equal or greater injury, is exempt from criminal liability because he does not act with freedom. So there are three requisites for that. So the first one is the force is physical. The second is the force is irresistible and could not be overcome by the volition of the offender. And the third one is the force should come from the third person and not from the offender himself. Now let's have an illustration for that. So for example, a taxi driver was stopped at gunpoint by robbers who were being chased by the police. So the driver has no choice but to obey the instruction of the robbers, and this facilitated their escape. So the question now is the taxi driver criminally liable? The answer is no, because the taxi driver was just acting under the compulsion of an irresistible force, so his action, therefore, is not voluntary. Now let us proceed to paragraph 6 of the Article 12, which talks about any person who acts under the impulse of an uncontrollable fear of equal or greater injury. So the fear must be grave, actual, and of that kind which ordinary men would succumb. So there are elements of uncontrollable fear. So the first one, the threat which causes fear of an evil greater than or at least equal to that which he is required to commit. And the second one is it promises an evil of such gravity and imminence that the ordinary man would succumb to it. Now let us discuss the last paragraph of Article 12, which is paragraph 7, which talks about any person who fails to perform an act required by law when prevented by some lawful or insuperable cause. So this crime of omissions. This is a crime of omission. So the requisites are the following. So the first one is the act is required by law to be done. And the second one is that the accused failed to perform the act required of him. And then the third one is that his failure was due to some lawful or insuperable cause. So thus, if a priest in the confessional had acquired the knowledge of an existing conspiracy to commit treason and he did not divulge it to the proper authority, is the priest liable of misprision of treason? No, he is exempt from criminal liability since he is not duty-bound to report the said information, considering the fact that the confession is a privileged communication between the priest and the penitent. So in this case, the priest failed to perform his act which is required by law because he was prevented by a lawful cause. And now let us proceed to the next article of the Revised Penal Code, which is Article 13. Article 13 talks about mitigating circumstances. So first, we need to define what is mitigating circumstances. So definitely, mitigating circumstances are those circumstances if present in the commission of the crime will have an effect in reducing the penalty, either by degree or degrees if they are privileged, or by periods if they are ordinary or generic. So in this article, we have 10 paragraphs, and in the next video, we will discuss each of the paragraph in detail. There are two kinds of mitigating circumstances. So the first one is ordinary mitigating circumstances, which can be offset by the presence of an ordinary aggravating circumstances and will have the effect of reducing the penalty by periods. And the second one is the privileged mitigating circumstances, which will have the effect of reducing the penalty by degree and will not be offset by the presence of ordinary aggravating circumstances. So these privileged mitigating circumstances are the following. So the first one is minority. The second one is incomplete justifying or incomplete exempting circumstances, which we will discuss in paragraph 1 of Article 13. And the third one is when there are more than one mitigating circumstance and there is no aggravating circumstance. And now let us discuss the first paragraph of Article 13, which stated that those mentioned in the preceding chapter, when all the requisites necessary to justify the act or to exempt from criminal liability in the respective cases are not attended. Paragraph 1 basically refers to incomplete justifying or incomplete exempting circumstances. There is lacking in his defense some requisites which would completely justify his act, or for him to be totally exempted from criminal liability. So for example, in self-defense, so defense of relative or defense of stranger, the requisite of unlawful aggression must be present, otherwise the accused could not avail of the mitigating circumstance of incomplete self-defense or incomplete defense of relative or incomplete defense of stranger, notwithstanding the presence of majority of the requisite. So let's have the example of the case of People versus Henrique. So when the accused killed the man who touched her private parts inside the church, where she stabbed the man to death, there was unlawful aggression on the part of the victim. There was lack of sufficient provocation on the part of the person defending herself. But the second requisite, the reasonable necessity of the means employed to prevent or repel the aggression, was lacking. So the Supreme Court appreciated in her favor the mitigating circumstance of incomplete self-defense. So the penalty is provided under Article 69 of the Revised Penal Code and is usually at least a degree lower than the penalty of the crime charge. Now let us proceed to the second paragraph of Article 13, which stated that the offender is under 18 years of age or over 70 years. In the case of the minor, he shall be proceeded against the accordance with the provision of Article 80. So, a privilege mitigating circumstances only refers to those of minorities, not on those age which is over 70 or seniority which is only an ordinary mitigating circumstance. With the passage, however, of RA 9344, a person over 15 but under 18 years of age is now exempt from criminal liability unless it can be established that he or she acted with discernment. So thus, under RA 9344, this circumstance is not only mitigating, it could be an exempting circumstance. Now let us define the word discernment. So what does discernment mean? So basically discernment refers to the minor's mental capacity to distinguish or to understand the difference between right and wrong. Now let us proceed to paragraph 3 of Article 13, which stated that the offender had no intention to commit so grave a wrong as that committed. So basically, paragraph 3 talks about the mitigating circumstance of lack of intent to commit so grave a wrong as that actually perpetrated cannot be appreciated where the acts employed by the accused were reasonably sufficient to produce and did actually produce the death of the victim. So the lack of intent to commit so grave a wrong may not be considered in conspiracy, since act of one is the act of all. Also, the lack of intent to commit so grave a wrong as that committed cannot be appreciated as mitigating in a case where the accused struggled a 6-year-old girl to death while he was raping her. Now let's talk about paragraph 4 of Article 13 of the Revised Penal Code, which stated that sufficient provocation or threat on the part of the offended party immediately preceded the act. Let us define provocation. So provocation is defined to be an unjust or improper conduct or act of the offended party capable of inciting, exciting, or irritating someone. So the term sufficient provocation or threat as understood under Article 13, Paragraph 4 of the Revised Penal Code mean that the provocation or threat should be proportionate to the act committed and adequate to steer one its commission. The sufficient provocation or threat must come from the offended party, and that must immediately precede the act complained of. What is sufficient also depends on the circumstances of the person, time, and place. So provocation is sufficient if it is adequate to excite a person to commit the wrong, which must accordingly proportionate in gravity. Now let us proceed to paragraph 5, which stated that the act was committed in the immediate vindication of a grave offense to the one committing the felony or delito, his spouse, ascendants, descendants, legitimate, natural, or adopted brothers or sisters or relatives by affinity within the same degrees. Now let us define grave offense. So, grave offense could mean a serious assault on the honor or reputation of a person or to his relatives mentioned in the provision. Before this mitigating circumstance can be appreciated, the offended party must have committed a grave offense to the offender or to the offender's relative. So, moreover, the grave offense and the act of the accused must have proximity in time. So, the question of whether or not a certain offense is grave is dependent upon such factors as the social standing of the person, the place and the time when the insult was made. So there can be no immediate vindication of a grave offense when the accused had sufficient time to recover his serenity. Like any other modifying circumstance, vindication should be affirmatively proven. Now let us proceed to paragraph 6 of Article 13, which stated that of having acted upon an impulse so powerful as to have naturally produced passion or obfuscation. So this passion or obfuscation must come from a lawful sentiment or feeling. So it could not be validly appreciated if it emanated from an unlawful relationship. Thus, a man who killed the husband of his paramour out of jealousy when he saw them kissing inside a theater could not claim this as a mitigating circumstance. But a husband who backs a man when he saw him kissing his wife could avail of this mitigating circumstance. There are two requisites of passion and obfuscation as a mitigating circumstance. So the first one is there should be an act both unlawful and sufficient to produce such condition of mind. Then the second one is the said act which produced the obfuscation must now be far removed from the commission of the crime by considerable length of time. So passion cannot coexist with treachery because in passion the offender loses his control and reason, while in treachery the means employed are consciously adopted. So one who loses his reason and self-control could not deliberately employ a particular means, method, or form of attack in the execution of the crime. Now let us proceed to paragraph 7 of Article 13, which stated that the offender had voluntarily surrendered himself to a person in authority or his agents, or that he had voluntarily confessed his guilt before the court prior to the presentation of the evidence for the prosecution. So, in order that a voluntary surrender will be appreciated as mitigating circumstance, so it must be to a person in authority or his agents with the intent to submit himself to the authorities either because he acknowledged his guilt or he wishes to have saved the government the trouble and expense incidental to his search and capture. So voluntarily surrender may also be inferred from the accusation of the person. For, for voluntarily surrender to be appreciated as mitigating circumstances, so the following requisite must occur. So the first one is that the offender has not been actually arrested, and the second one is the offender surrenders himself to a person in authority or his agents. And the third one is the surrender is voluntarily. Voluntary plea of guilty, on the other hand, refers to the plea of guilty on the part of the accused, which he will enter before the prosecution commences the presentation of evidence against him. So the requisites for it to be appreciated it as a mitigating circumstance are the following. So the first one is that the offender is spontaneously confess his guilt, and the second one is that the confession of guilt was made in open court of competent jurisdiction which tried the case, and the third one is that the plea was made before the prosecution commencement the presentation of evidence. So the mitigating circumstance of voluntary voluntary surrender and voluntarily plea of guilt should be appreciated separately. When an accused pleaded guilty to a capital offense, the court must, number one, conduct a searching inquiry into the voluntariness of the plea of the accused's full comprehension of the consequence thereof. Then the second one, it is the prosecution to present evidence to prove the guilt of the accused and his precise degree of culpability. And then the third one is ask the accused if he desires to present evidence on his behalf. Let us proceed to paragraph 8, which stated that the offender is deaf and dumb, blind or otherwise suffering from physical defect which restricts his means of action, defense or communication with his fellow beings. Basically, paragraph 8 refers to some physical defects on the part of the accused which limits his capacity to communicate. So the mitigating circumstance may be appreciated if, for example, a person who is a deaf mute have been maligned in public, and since he cannot respond verbally to the verbal assault of the offended party, he got a piece of wood and whacked the latter. And another example for that is when a deaf mute wanted to buy an item from the store, but he could not be understood by the sales girl, who later on left him, and as a result, he took the item without paying it. Could use It could be used as a mitigating circumstance when prosecuted for theft. Now let us proceed to paragraph 9, which stated that such illness of the offender as would diminish the exercise of the willpower of the offender without however depriving him of consciousness of his act. This paragraph, this kind of illness which affects the willpower of the offender and which could not be considered as insanity, as it does not deprive the offender of the capacity to discern and appreciate the distinctions between right and wrong, and the capability to determine the nature and the consequence of his act. And finally, for the last paragraph, it talks about any other circumstances of a similar nature and analogous to those above mentioned. So it is to be noted that the foregoing enumeration of the mitigating circumstances are not exclusive. So there are other circumstances which are of similar nature and which when proven will have the effect of reducing the penalty. So like for example, restitution of defense malversed, which equivalent to voluntary surrender. And that's all for Article 13, Mitigating Circumstances. And now let us proceed to Article 14, which talks about aggravating circumstances. So first, we need to define aggravating circumstances. So aggravating circumstances are those which attended or are present in the commission of the crime and which have the effect of either qualifying or changing the nature of the crime, thereby increasing the penalty to a higher degree, or which, when present in the commission of the crime, will increase the penalty by period. So in this article, we have 21 paragraphs which we are going to discuss in detail in the next video. So now let us discuss the classification of aggravating circumstances. So first one, we have the generic aggravating circumstances, which are those that generally apply to all crimes, such are those mentioned in Article 15 from paragraphs 1 to paragraphs 20. So, in this classification, it have the effect of an increasing the penalty for the crime to its maximum period, but it cannot increase the same on the next higher degree. So the next one or the second one is what we call special aggravating circumstance. Those are which arise under special conditions to increase the penalty to the next higher degree. So the meaning and effect of the generic and the special aggravating circumstances are exactly the same, except that in case of generic aggravating, the same can be an offset by an ordinary mitigating circumstance, whereas in the case of special aggravating circumstance, it cannot be offset by an ordinary mitigating circumstances. And the third one is what we call qualifying. Those are which changes the nature of the crime, as from homicide to murder or homicide to parricide. Then the next one is the fourth one is what we call inherent. So those are which are necessarily present in crime but are not used in the definition thereof. Like for example, the abuse of public position in bribery and malversation, fraud, and stapa. And the last one is what we call specific. So those are which apply to particular crimes such as cruelty and treachery, which can be up, which can be appreciated only in crimes against person. Now let's talk about the first paragraph of Article 14, which talks about the advantage was taken by the offender of his public position. So in this paragraph, it talks about the this aggravating circumstance. In order to be appreciated, it is not only necessarily that the person committing a crime will be a public official, but he must also use the influence or the prestige or ascendancy which such office gives him as a means by which he realizes his purpose. Have an example for this paragraph. So supposing a policeman in complete uniform knocked at the gate of a house and told the occupants thereof that he was chasing a killer, and he saw that the killer climbed the wall in the house. So in this pretext, and having proven that he is a real policeman, so he was allowed by the occupants to enter the house. But once the policeman uh, set inside the house, he robbed the occupants. So it is submitted that this aggravating circumstance of taking advantage of his public position may be validly appreciated. But on the other hand, if he is not a policeman and he was just using a uniform of a policeman in order to gain entry, so these aggravating circumstances will not be appreciated because the proper aggravating circumstances will be the employment of craft fraud or disguise. Now let's proceed to the second paragraph, which stated that the crime be committed on contempt of or with insult to public authority. Basically, a public authority refers to a person who is vested with jurisdiction either as an individual or as a member of a board, tribunal, or commission. So if the crime was committed in the presence of a policeman, can this aggravating circumstance be validly appreciated? No, it is because a policeman is not a public authority, but merely an agent of a person in authority. So it must be established that the offender knows that a public authority is present, and still he committed the crime as a manifestation or expression of his contempt or insult to such authority. Have an illustration for this paragraph. So for example, X is in the presence of mayor slap Y, which is the younger brother of the mayor. Just prove that to those who were around that the mayor cannot do anything against him and that he can do anything with impunity. So this aggravating circumstance may be appreciated against X. Now for the third paragraph of Article 14, which talks about that the act be committed with insult or in disrespect of the respect due the offended party on account of his rank, age, or sex, or that it be committed in the dwelling of the offended party when the latter has not given any provocation. So in this paragraph, so there are actually two aggravating circumstances which can be validly and separately appreciated under this particular provision. So the first one is the commission of the crime which with insult or disrespect due to the offended party on account of his rank, age, or sex, and the other one is the commission of the crime in the dwelling of the offended party when the latter has not given any provocation. So in the first part, the person with the rank or age or weaker sex is the offended party. So this disrespect rank, however, should not be considered aggravating in the crime of direct assault, since it is already an element of the crime. So for this aggravating circumstance to be appreciated, so there must be proof which would clearly demonstrate that the accused deliberately intended to with insult or disregard to respect on the account of the rank. Aggravating circumstance of disrespect on account of age or disregard of sex can be appreciated only in crimes against person or and honor. While on the dwelling of the offended party is aggravating when the crime was committed thereat, provided that there was no provocation on the part of the former. So, so what is dwelling? So dwelling also includes dependencies of a house where the offended party lives. So for purposes of this provocation, so the boarding house where a person like a student resides may be considered a dwelling. Let us proceed to paragraph 4, which stated that the act be committed with abuse of confidence or obvious ungratefulness. In this paragraph, there are also two aggravating circumstances mentioned, namely abuse of confidence and abuse of ungratefulness. So first, let us talk about abuse of confidence. So abuse of confidence is present where the victim considered the accused a trusted houseboy, where the victim's confidence and trust in accused facilitated the commission of the crime. So there was abuse of confidence. So this could not be appreciated when the victim lacked confidence in the accused as shown by her his hesitance as shown by her hesitance and reluctance to accompany him. Following are the requisites for abuse of confidence to be appreciated as aggravating circumstance. So the first one is the offended party had trusted the offender, and the second one, the offender abused the trust, and the third one is the trust facilitated the commission of the crime. Let's talk about aggravating circumstances of obvious ungratefulness that must be manifest and clear. So, for example, in the case of the offender killed his father-in-law who supported him in his financial needs, the offended party also allowed him to stay in the house. So the accused, in convincing the accused, the court correct the court correctly considered obvious ungratefulness as an aggravating circumstance. Now let's proceed to paragraph 5, which talks about that the crime be committed in the palace of the chief executive or in his presence or where public officials are engaged in the discharge of their duties or in a place dedicated to religious worship. In this paragraph, so there are three aggravating circumstances mentioned. So the first one is when the crime committed in the palace of the chief executive in his presence. The second one, or when the crime is committed in the place where public officials are engaged in the performance of their duties. And the third one is when the crime is committed in the place dedicated to religious worship. The crime is committed in the palace of the chief executive, which is also known as Malacanang Palace, so it is not necessary that the chief executive is present. So if the crime is committed in his presence, it is not also essential that the crime be committed in Malacanang. So it is not also necessary that the president or the chief executive be engaged in the discharge of public functions. While in the crime committed in a place where public officials are engaged in the performance of their duties, so it must be at such time or occasions when the crime was committed, while the public officials are performing their duties. Thus, it could not be considered aggravating when in the wee hours of the morning a security guard of the Hall of Justice killed his fellow guard due to a misunderstanding. So and the last one is when the aggravating circumstances of committing the crime in a place dedicated to religious worship may be appreciated if the offender purposely chose or deliberately elected to commit the crime in such sacred place, which refers to churches, chapels, temples, and mosque. Thus, in the case of People versus Henrique, where the accused worry of amorous advances of a very ardent suitor started bringing a fun knife, and when she went to church, the victim followed her and started touching her private parts. And then the accused stabbed him with her fun knife, resulting to his death. So the aggravating circumstance of committing the crime in a place dedicated to religious worship is not present, since the accused had not purposely gone to church in order to commit the crime. Now let us proceed to paragraph 6, which stated that the crime be committed in the nighttime or in an inhabited place or by a band whenever such circumstances would facilitate the commission of the offense. Whenever more than three armed malefactors shall have acted together in the commission of an offense, it shall be deemed to have been committed by a band. Basically, nighttime is not really an aggravating circumstance as well as nocturnity. So it only becomes an aggravating circumstances when number one, it is specially sought by the offender. Number two, it is taken advantage of by him. And the third one is it facilitated the commission of the crime. So the commission of the crime by ensuring the offender's immunity from identification or capture is an inhabited place or despoblado. So this may not be appreciated where the nearest house from the scene of the crime was merely 150 meters away. So an inhabited place may be considered when the crime was committed at sea. So commission of the crime in an uninhabited is merely generic, and that qualifying which only increase the penalty of the crime to its maximum period, but not increase the same to the next higher degree. The last one is when the crime committed is by band. So what is the meaning of band? So literally band consists of at least four armed persons grouping together for the purpose of carrying out criminal intention. So when there are 100 persons or even more, but only one or two or three are armed, it is not considered as a band. So in the crime of robbery with rape, band is an aggravating circumstance. Let us proceed to the seventh paragraph of Article 14, which stated that when the crime be committed on occasion of conflagration, earthquake, shipwreck, or other calamity or misfortune. So the reason for the aggravation of moral depravity of the accused who instead of helping people who are suffering from a calamity, so instead of extending his helping hand on those who are victims thereof, add to their suffering by taking advantage of their misfortune. Thus, this aggravating circumstance may be appreciated against those people who carted away the personal belongings of a fire victim, or again those who stole the cattle of a farmer who fled away due to the incoming flood. And now let us proceed to paragraph 8, which stated that the crime be committed with the aid of armed men who ensure or afford impunity. So the requisites of aid of armed men as aggravating circumstances are, so number one, that the armed men or persons took part in the commission of the crime directly or indirectly, and the second one is that the accused availed himself of their aid or relied upon them when the crime was committed. So for example, an example is when a bully slapped a man with impunity because of the presence of his armed bodyguards. So the men act as accomplices only. They must not be acting in the commission of the crime under the same purpose as the principal accused. So otherwise, they are to be regarded as co-principals or co-conspirators. Now for paragraph 9, which stated that the accused is recidivist. So a recidivist is one who at the time of his trial for one crime shall have been previously convicted by final judgment of another crime embraced in the same title of this code. So in recidivism, the succeeding offense must be committed after the commission of the first offense, and that at the time of his trial for the second offense, he had been already convicted at the first time. So both the first and the second offense must be embraced in the same title of the code. Thus, there will be no recidivism if the second crime have been decided first and the second conviction was the first offense. Now let's proceed to paragraph 10, which talks about that the accused had been previously punished for an offense to which the law attached an equal or greater penalty, or for two or more offenses to which the law attaches a lighter penalty. So this paragraph, this is what we call reiteration, which is under the Spanish Código Penal. So it requires not just prior conviction, but prior punishment. So the offenses are not necessarily under the same title of the code. So if the previous crime to which the accused was punished is graver, so is graver than the second crime, then one prior punishment of a crime is enough. So moreover, unlike habitual delinquency, there is no time frames to when the second crime was committed after the accused had been punished. Let us proceed to paragraph 11, which stated that the crime is committed on consideration of price, reward, or promise. So in this aggravating circumstance, there must be at least two persons involved. So the giver of the price, reward, or promise, who is technically known as the principal by inducement, and the taker of the said price, reward, or promise, or the principal by direct participation. So it is not enough that the principal by direct participation or the one committed the crime had received the price, reward, or promise. It must be also established that the said reward or price is the prime consideration of the price. So for example, in the case of US versus Paro, the Supreme Court ruled that both the giver and the taker must suffer the aggravating circumstance of price, reward, or promise. Now let us proceed to paragraph 12, which stated that the crime be committed by means of inundation, fire, poison, explosion, stranding of a vessel, derailment of a locomotive, or intentional damage thereto, or by means of any other artifice involving great waste or ruin. So, the basis of this aggravating circumstance is the great waste and ruin which will result by using any of ways and means mentioned in order to commit the intended crime. Thus, if the accused wanted to destroy the house of his rival, and in doing it he destroyed the dike in order to inundate the lowland where the house of the victim is situated, great waste is caused by such acts. So this may also be appreciated when in order to kill one person. So the killer used a grenade while the victim was attending a public function which resulted to a killing of several people. Now let us proceed to paragraph 30, which talks about that the crime be committed with evident premeditation. So, in these aggravating circumstances, it is necessary to prove the time when the offender has determined to commit the crime, and the act manifestly indicating that the culprit had clung to his determination and sufficient time between determination and execution of the crime have lapsed to allow him to reflect upon the consequence of his act. So the essence of premeditation is the execution of the criminal act, which must be preceded by cool thought and reflection upon the resolution to carry out the criminal intent during the space of time sufficient to arrive at the calm judgment. So it must be appear not only that the accused had formed a determination to commit the crime prior to the moment of its execution, but that the determination was the result of meditation, calculation, reflection, and persistent attempts. So the premeditation must be evident, which means that the accused had clung to his criminal design from the moment he decided to commit the crime until that moment when he actually committed the same. Let us proceed to paragraph 14, which stated that craft, fraud, or disguise be employed. So craft involves intellectual trickery and cunning on the part of the offender. So craft, fraud, or disguise is a species of aggravating circumstance that denotes intellectual trickery or cunning resorted to by an accused to aid in the execution of his criminal design or to lure his victim into a trap and to conceal the identity of the accused. Thus, there must be concealment of identity of the accused. Now let us proceed to paragraph 15, which stated that advantage be taken of superior strength or means be employed to weaken the defense. So to take advantage of superior strength means to purposely use excessive force out of proportion to the means of defense available to the person attacked. So to consider abuse or superior strength, there must be a marked disparity of strength between the perpetrator and the victim. So there must be evidence of notorious inequality of forces brought about by the disparity of age, sex, size, and strength, and that the offender took advantage of his marked superiority in committing the crime. Abuse of superior strength is present when the offenders took advantage of their combined strength in order to consummate the offense. Now let us proceed to paragraph 16, which stated that the crime be committed with treachery. There is treachery when the offender commits any of the crimes against the person, employing means, methods, or forms in the execution thereof, which tend directly and specially to ensure its execution without risk to himself arising from the defense which the offended party might take. So, in order for a treachery to exist, so two essential elements must concur. So, the first one is the employment of means, method, or manner of execution that gives the person attacked no opportunity to defend himself or to retaliate. And the second one, the means. And the second one is the means or method of execution was deliberately adapted. So it must be present at the inception of the attack, and if absent and the attack is continued, even if tertiary is present at the subsequent stage, it is not be considered. And now let's go to the 17th paragraph of Article 14, which talks about that means be introduced or circumstances brought about which add ignominy to natural effects of the act. So what does ignominy means? So it means disgrace, dishonor, loss of reputation, humiliation or contempt. So in a layman's expression, it means adding insult to injury. So which uh, ignominy produces mental, emotional, or physiological suffering rather than physical suffering. So in one case, the act of the accused who after raping the woman placed mud on the vagina of the victim was considered as adding ignominy of the natural effects of crime. Let us continue our discussion to paragraph 18 of the Article 14 of the Revised Penal Code, which stated that the crime be committed after an unlawful entry. So there is an unlawful entry when an entrance was affected by a way not intended for the purpose. So it is an aggravating for the reason that one who violates the wall erected by men to guard their property and their privacy and to provide for their personal safety shows greater perversity. So it is inherent in the crime of robbery with force upon things, violation of domicile, and trespass to dwelling. Now let's continue our discussion to paragraph 19, which talks about that as a means of committing a crime, a wall, roof, floor, door, or window be broken. So, in this aggravating circumstance, so it is not necessary that the offender should have entered the building. So, it is enough that as means of committing the crime, a wall or roof, floor, or window be broken. Let us proceed to paragraph 20, which talks about that the crime be committed with the aid of persons below 15 years of age or with the use of motor vehicles, airships, motorized watercraft, or other similar means. So the use of minors in committing a crime shows greater perversity on the part of the offenders, as they are taking advantage of the youthfulness of those persons for criminal purposes. So the aggravation when the criminals use motor vehicles and other similar means in committing crimes is intended to meet the problem created by modern criminals in resorting to faster means of conveyance to commit the crime. Now let's talk about Article 15. Their concept. Alternative circumstances are those which must be taken into consideration as aggravating or mitigating according to the nature and effects of the crime and the other conditions attending its commission. They are the relationship, intoxication, and the degree of instruction and education of the offender. Alternative circumstance of relationship shall be taken into consideration when the offended party is the spouse, ascendants, descendants, legitimate, natural or adopted brother or sister, or relative by affinity in the same degree as the offender. The intoxication of the offender shall be taken into consideration as a mitigating circumstance when the offender has committed a felony in a state of intoxication if the same is not habitual or subsequent to the plan to commit said felony, but when the intoxication is habitual or intentional, it shall be considered as an aggravating circumstance. So basically, Article 15 talks about alternative circumstances which can either be treated as aggravating or mitigating, which depends upon its situation, namely relationship, intoxication, and degree of instruction. So, in crimes against persons, relationship is generally aggravating if the offended party is a relative of higher degree or when the offender and the offended party are relatives of the same level, like brothers, sisters, cousins, etc. While relationship is mitigating if the offended party is of lower degree than that of the offender. It is submitted, however, that relationship in the crime rape is still aggravating, although it is now reclassified as a crime against person. Intoxication generally is mitigating since the judgment and reasoning of a person is intoxicated is affected enough to deprive him of full discernment of the nature and consequence of his action. However, if intoxication is habitual or was deliberately made in order to embolden him to push through with the criminal resolution, in effect, it was subsequent to the plan to commit the crime, then intoxication is aggravating. Let's go to the degree of instruction. So the degree of instruction is aggravating when the offender took advantage of his profession or education in order to commit a crime. So for example, if a lawyer commits staffa or when a doctor commits murder using some special substance which he knew or obtainably by him, by reason of his profession, degree of instruction is aggravating, while on the other hand, it is mitigating when the offender is suffering from the inability to comprehend and discern the meaning of what he is doing. It refers to the lack of sufficient intelligence and knowledge of the full significance of one's act. And now let us proceed to Article 16 of the Revised Penal Code. So basically, Article 16 talks about who are criminally liable. So for grave felonies, so the following are criminally liable. So the first one is the principal, the second is the accomplice, and the third one is the accessories. While for the light felonies, there are only two who are criminally liable. The first one is the principal and the second one is the accomplice. The definition and explanation for the principal, accomplice, and accessories will be discussed on the next article. Article 17. So in this article, we will discuss in detail what is principal. So the following are considered to be a principal. So the first one, those who take a direct plan in the execution of the act. Second is those who directly force or induce others to commit the crime. And the third one are those who cooperate in the commission of the crime by another act without which it would not have been accomplished. A principal by direct participation is the person who actually committed the crime. So he is the person who performs the act of execution, which produces a felony as a consequence. A principal by inducement is that principal who did not actually committed a crime. So his participation is only limited by giving incentive to the principal by direct participation to commit a crime. So this person basically are those person who gives prizes or reward before or after the commission of the crime. Although the inducement may take the form of command, advice, an ironical phrase, a thoughtless expression, or a wishful thinking, for as long as the person who gave the advice or false thought did not have the malice or intention to cause or induce the other to commit the crime, the giver thereof cannot be held liable as principal by inducement. Thus, for example, a father who upon seeing his son with a bloody nose from the fight with the neighbor and commented that if he was the one with the injury, he would kill his adversary, and the son after contemplating his split killed his opponent, could not be considered as principal by inducement, since the same was merely thoughtless reaction to the sight of his son. But if a father who has who has who has a moral ascendancy over a 5-year-old son, and who commanded his son to steal money from his grandfather, then therefore the father would be liable for theft as a principal inducement if indeed the boy if indeed the boy stole the money as commanded. The principal by indispensable cooperation is the person who did not directly commit the act of execution which produces a felony, but he cooperated by another act which is indispensable and without which the crime would have not been accomplished. In order to make a person criminally responsible as principled by indispensable cooperation, the following requisite must occur. So the first one is the unity of criminal resolution and intention. The second one is the cooperation for the accomplishment of the intended crime by committing another act. And the third one is without him performing an indispensable but another act, the crime would not have been committed. Now let us proceed to Article 18. Article 18 talks about accomplice. So basically, accomplice are the persons who not being included in Article 17 cooperate in the execution of the offense by previous or simultaneous act. So what is an accomplice? So an accomplice is the one who cooperates in the execution of the offense by acts prior to or simultaneously therewith. So in order that a person may be considered as an accomplice, the following requisites must occur. So the first one is community of design. The second one is he cooperated in the execution of the crime by previous or simultaneous act. And the third one is there must be the relation between the acts done by the principal and the acts of those attributed to the person charged as accomplice. Accomplice do not decide whether the crime should be committed. They merely assent to the plan and cooperate in its accomplishment. So compared to the principal, accomplice has a lesser criminal liability because because the degree of the participation of an accomplice is lesser than those of that principal. Now let us proceed to Article 19, which talks about accessory. So accessory are those who, having knowledge of the commission of the crime and without having participated therein, either as principal or accomplice, take part subsequent to its commission on any of the following manners. So the first one, by profiting themselves or assisting the offenders to profit from the effects of the crime. Second, by concealing or destroying the body of the crime or the effects or instruments thereof in order to prevail its discovery. And the third one is by harboring or assisting in the escape of the principal of the crime, provided the accessory acts with abuse of his public functions, or whenever the author of the crime is guilty of treason, parricide, murder, or an attempt to take the life of the chief executive, or is known to be habitually guilty of some other crime. So Article 19 and Article 20 must be correlated. While Article 19 provides the three kinds of accessories, Article 20 provides for relationship as an exculpatory cause. And now let's have an illustration. So for example, Juan killed Pedro or Juan stabbed Pedro using a knife. So in order for Juan to prevent his arrest, Juan directly escaped from the crime scene, which in which he forget the knife that he used to kill Pedro, which bore his fingerprints. So basically, Juan then called his father Jose in order to throw away the knife that he used in killing Pedro, and also threw away the dead body of Pedro. So the question here is Jose, which is the father of Juan, is an accessories? Yes, that is provided on the paragraph 2 of the article 19, which talks about concealing or destroying the body of the crime or the effects of instruments thereof in order to prevent its discovery. And the other question is Jose a criminally liable? No, because Jose is Juan's father, and this is according to Article 20, which is an exemption of him being a criminally liable. And we will discuss Article 20 next. And now let us talk about Article 20, which is correlated with Article 19 of the revised penal code. So basically, Article 20 talks about the accessories who are exempt from criminal liability. So the penalties prescribed for accessory shall not be imposed upon those who are such with respect to their spouse, ascendants, descendants, legitimate, natural and adopted brothers and sisters, or relatives by affinity, within the same degrees, with the single exception of accessories falling within the provisions of paragraph 1 of the next preceding article. Accessories who are not exempt from criminal liability are those who profited themselves or who assisted the offenders profit from the effects of the crime or both. It is also to be noted that the penalty of the accessories is generally 2 degrees lower than that imposed upon the principal of the crime. That ends this video presentation. So I hope you learned something from this. Thank you so much for watching, and God bless us.